so we will go ahead and kick off here. And again, welcome everybody. So today we are talking about the FATF 5th round mutual evaluation review. It's kind of the process, and Elizabeth will be presenting to us today. Today's topic is important for the AML professional and for the business leaders. And I'm sure we have a few business leaders, of course, as well as the regulators themselves. Because gray listing is a business risk, it's not just a compliance risk. If your jurisdictions ends up on the gray list, it's something we want to avoid, has regional impact. And as Elizabeth will point out, that kind of leadership tone and compliance is going to be assessed in the private industry. And for the compliance officers, our work is being judged as well. We're being graded, and the effectiveness bar, what we did 5 years, 10 years ago, is no longer possibly deemed effective. So, we might have to kind of raise our work there. And just to remember that when we are during an assessment season, we are in the same room with those regulators and we are on the same team. So we do need to work together. So I hope Elizabeth can explain the process more and help us all out here. So a little housekeeping before I hand over to Elizabeth. This is just informational purposes only. Elizabeth is a lawyer, but this is not legal advice. We should last 1 hour. We might have to rush through it a little bit, but about 1 hour is when we'll end. There is a certificate of attendance that will be generated to all attendees of the live broadcast. We are going to wait for questions at the end. So you put any comments and questions in the question box. I'm going to let Elizabeth present, and then we will do questions at the end. And we do have some upcoming topics in June and July, so do continue to follow us, and I hope I will see you at future webinars as well. I will turn off my camera. Elizabeth, you're welcome to turn yours off as well so people can focus on the slides. And let's go ahead and kick off. I don't know if you want to kind of explain your background, Elizabeth, and how you've been involved in these evaluation reviews as well.
Okay. Thanks so much, Kimberly. Thank you for having me. So my background is as a lawyer and as a prosecutor and a barrister earlier on, and then as the national coordinator for the Cayman Islands after the 4th round mutual evaluation was published, and now assisting regulated entities with legal advice, as well as at the country level, assisting with preparations for or remediation after mutual evaluations, or in the case of grey listing, the reports and process for delisting. So thanks so much for having me today to talk about these 5th rounds, which have now started. And just to give an overview of what I'm going to talk about today, I'll talk a bit about the process and what's changed in this round. I'll talk about the grey listing and also what has changed there. And then finishing off with the role of industry, which I'll also touch on as we go through. As you said, there's quite a lot of information. I won't obviously read it all out, and I know, Kimberly, you'll share the slides as you always do. So I'll give an overview as we go through, and then I will be happy to take questions at the end. So starting off with the procedures itself, you can see here the procedures document, the FATF procedures document. All the documents are public on the website, procedures, methodology, and of course the recommendations themselves. So just starting with some of the key terms, the assessment team will be drawn, each member from a different country, and they will represent law enforcement, financial services, a legal member, a lawyer, and that will normally be about 5 to 6. We normally see around 5 members of an assessment team in the CFATF mutual evaluations. The secretariat will be CFATF or FATF, or whichever FATF body is in charge of that evaluation. And in some lesser cases, we also see the INF serve as secretariat. A scoping note will be provided by the team, identifying which areas are deemed to be of higher risk and which areas are deemed not to be so relevant to the assessment, which is a useful starting point to see where the team is going to focus. The Secretariat will provide pre-assessment training before the process begins, and the process consists really of two parts. A technical compliance section, are the rules and regulations in place, and then effectiveness, how well are they being used. Now, as we've progressed through these evaluations and into the fifth round, the focus now is much more, as you said earlier, Kimberly, on effectiveness. And that's also demonstrated by the fact that for technical compliance, we now have recommendations under review, which means that only those recommendations which have changed will be reviewed and changed either by the FATF requirements or by the country's response. So the focus will be on effectiveness, and these are the 11 immediate outcomes for effectiveness. So you can see that they range from IO1 risk, which is absolutely key and which transcends through the other immediate outcomes. It looks at international cooperation, both at the formal mutual legal assistance level as well as the informal levels, such as police to police. And then one important change that we can already see here is immediate outcome 3 and immediate outcome 4 have now been separated. One looks at financial institutions and BASPs, and one looks at DNFBPs, which is lawyers, accountants, dealers in precious metals and stones, TCSPs, the non-financial institutions. Of key focus, and we'll talk about this a bit more, is of course beneficial ownership. And then you can see that IO 6, 7, and 8 take us from financial intelligence, and that's SAR filing, through to investigation and prosecution, and then the confiscation of the proceeds. There's also a section on terrorist financing, as well as on sanctions as it relates to terrorist financing and proliferation financing. So it's very broad, and as you can see on the next diagram, I've given the example of the Cayman Islands. And there you can see how broad it is. So we have all the supervisors on the right-hand side, from the financial institutions to the DNFBPs. We have all the parts that participate in law enforcement, from the FIU up to the police and customs, and then the prosecution. So also on the right-hand side, as well as the supervisors, we obviously have the supervised sectors, and they play a really important role, as we'll see, because the assessors will be looking at their levels of compliance and what the supervisor has done to engage and to provide guidance, and of course to monitor and enforce compliance. So the process itself begins about 7 months prior to the on-site with that technical compliance submission. Now that's largely paper-based. Do we have all the laws and regulations in place? Then on to the effectiveness submissions. How well are we using them? The on-site itself will take 2 to 3 weeks. And then after the on-site, there will be various drafts of the mutual evaluation report for review before finally getting to plenary discussion. So for a FATF evaluation, the plenary discussion will likely be 8 months after the on-site. And of course, 7 months prior to the on-site, you've commenced with your submission. So it's a long process. And the process involves looking at data for 4 to 5 years prior to the evaluation itself. So really, preparation cannot begin early enough. When the assessors are looking at those effectiveness submissions and coming on site and speaking to the public and the private sector, they'll be grading the levels of effectiveness with one of 4 ratings. from low to moderate, substantial, high being the highest rating. Now, this will be important when we come on to the process of grey listing and what that relates to. So we had the process before, we had the ratings before. What's changed in this round? First of all, Kimberly, as we said, there's a greater focus on effectiveness. There's also a greater emphasis on risk and context, so understanding the risk of each jurisdiction, which of course is unique, and ensuring that mitigating measures are commensurate to that risk. The industry understands the risk and is also taking into account the findings of the risk and implementing commensurate mitigating measures. There's going to be a greater focus on asset recovery, which I'll talk about, beneficial ownership, which we mentioned, and of course now the risk of proliferation financing. As we said, there's that separation now between the financial institutions and the DNFBPs, which is really going to highlight any issues with the DNFBPs, the lawyers, the accountants, that may otherwise have been somewhat lost in the whole evaluation of all the sectors together. So at this stage, we already have 3 published 5th round mutual evaluations. So the 3 mutual evaluations are Malaysia, Latvia, and Belgium. These are all public. They can all be read and reviewed. And Latvia did really well. So I'm going to provide some examples from Latvia as we go through. So focusing a bit more on some of those areas of change. The first one being this increased focus on risk and context. So the risk assessments are absolutely crucial, both at the national level and at the sectoral level. The Cayman Islands is currently underway with its national risk assessment. The last one was 2021, and we expect the new risk assessment to be published later in 2026. And of course, industry will need to demonstrate that it understands those risks at the national level and at the entity level. Previously, FATF had conducted a review on what brings a good result for a mutual evaluation. And when they looked at IO1 in their report, which was published in 2022, they noted that sharing the national and sectoral risk assessments as widely as possible, interacting with the private sector and all relevant bodies, both at the risk assessments and of course at the end of the risk assessment, is absolutely crucial. Well, since then, we now have those 3 published reports that I mentioned. So if we look first at Latvia, Latvia did extremely well, as you can see here. So they got a number of highs, which is the highest rating that can be given. The rest was substantial, except for one, which was that IO4 in relation to those designated non-financial businesses and professions. So if we want to see what a high level of effectiveness looks like for immediate outcome 1, we can look at Latvia, and you can see now here what they said about Latvia. The understanding of the money laundering, terrorist financing risks is characterized by a genuine curiosity, a commitment to integrate a wide variety of data sources to generate and maintain an evolving, continuous, and in-depth understanding of past and present MLTF risks. So in that case, Latvia was awarded the highest rating for immediate outcome 1. And as you can see, and as I said, this then flows through all the other immediate outcomes. For example, immediate outcome 3 in relation to financial institutions and virtual asset service providers. They received a substantial grading, and it was noted that the private sector, who were interviewed by the assessors, demonstrated a very good understanding of national and sectoral risks and threats to which their specific businesses were exposed. So you can see how the risk factor feeds in to all the other immediate outcomes. The next area of focus, as we know, is beneficial ownership. We are seeing the misuse of entities in money laundering, terrorist financing, and proliferation financing. So knowing the beneficial owners and who is ultimately in control of those entities is absolutely crucial to prevent bad actors, but also to detect bad actors and to recover proceeds. So one of the changes here is that countries are now asked to consider the risk posed by foreign companies. And we've seen in the Cayman Islands that a lot of work has been done with the Beneficial Ownership Transparency Act and its regulations. And in terms of industry and what industry can do, of course, the assessors will be looking at the level of beneficial ownership information being filed and any findings where that information was not accurate and up to date. Again, Latvia received a high on this particular immediate outcome, so we can look to that report as an example. And it was noted that the adequacy and accuracy of the data contained in the registry in Latvia is ensured through the verification checks conducted by the authorities and discrepancy reporting mechanism. So it's not only non-filing or late filing, it's how are we ensuring that that beneficial ownership is adequate and accurate. So I mentioned that the Cayman Islands has done a lot of work on beneficial ownership transparency, and you can see here the wording, the requirement to have a register with adequate, accurate, and current beneficial ownership information. So the wording comes directly from FATF and is brought into law by the domestic legislation, which hopefully will put the Cayman Islands in good stead for recommendation 24. And then, of course, for immediate outcome 5, as we looked at with Latvia, the question will be, how well is that system working in practice? Another new area for immediate out for the 5th round is proliferation financing. We now have the requirement to conduct a risk assessment, both at the national level and at the entity level. So of course, we expect to see this in the upcoming national risk assessments for all jurisdictions, including the Cayman Islands in 2026. And the assessors will be interested to see whether industry is conducting their proliferation financing risk assessments and how well that is being monitored and supervised by their supervisors. Another key area that I referred to is asset recovery. As we know, that often cited statistic that only less than 1% of these global illicit financial flows are being recovered. So entities are going to great lengths to increase their compliance, to file their suspicious activity reports, and yet only this small amount is being recovered. So there is a real focus on how do we recover more of these illicit proceeds, and we've seen changes in the methodology requiring countries to not only have systems in place, but to monitor how well those systems are working and what can be done to increase the level of assets being recovered, whether it be through outgoing international requests, through domestic criminal confiscation measures or domestic civil recovery. And also that countries discuss at the highest level the priority of asset recovery at the national level and at the agency level. So one of the impacts on the Cayman Islands has been the introduction of the Defense Against Money Laundering SAR regime, where you must request consent before you move the suspected proceeds of crime after you have filed a SAR or otherwise deal with those funds. in a manner that may otherwise subject you to potential money laundering charges, and that then enables those funds to be kept in place, as it were, until you either receive consent or deemed consent, or indeed there's a refusal, so that the matter can be passed to law enforcement to take further action. So of course, in this case, from industry's perspective, the assessors will be looking at the level of SAR reporting, the quality of SAR reporting, and the DAML regime, as well as what cases has this led then to the freezing or recovery of assets. So if we take then again Latvia as our example, who received a high in immediate outcome 8, we can see that the assessors found that Latvia prioritizes asset recovery as a policy objective, that it has used provisional measures to freeze over 3 billion euros, that it has confiscated funds, and that its statistics align with Latvia's risks. So all of these elements have led to Latvia receiving a rating of high for immediate outcome 8. So those are some of the areas that the assessors will be looking at, either with increased focus or in IO3 and IO4 in a separate manner to how it was done before. One of the other changes is that when the assessors then make their recommendations as to what needs to be done to improve the system, these recommendations should be more results oriented, so that countries know exactly what they need to do, and key recommended actions will be identified. So previously, the country would receive a list of recommended actions for all immediate outcomes that didn't receive significant grades, and they were not separated as to which were key and which were not. Well, now countries will know when they receive their report, or indeed the reader reading the report, which of those recommended actions are key. So if we use Latvia as our example, as we saw, they only received one moderate rating, which is perhaps indicative of the fact that this was IO4 DNFBPs, a country that did so well fell down in this area of the DNFBPs, and they only had 2 key recommended actions, and they both related to this immediate outcome, and they related to the supervisors of the DNFBPs and their assessment of risk and their assistance in helping those DNFBPs rate their own risk. So we looked at Latvia as our example, and we saw that the Belgium and Malaysia reports have also been published. At the February FATF plenary, 3 further reports were approved: Austria, Italy, and Singapore. So they are expected to be published either this month or next month. We had the on-site of the United States scheduled for February. I think it took place in March. So that should be coming up for plenary discussion in October. The United Kingdom's on-site is in 2027. Trinidad and Tobago, the first CFATF country, now up for on-site inspection, followed by Bermuda, and we expect to see the on-site inspection of the Cayman Islands in December 2027, with the plenary discussion and the following publication of the report in 2028. So that was my whirlwind tour of mutual evaluations. And before we move on to grey listing, Kimberly, I think we have another poll question.
All right. That was a whirlwind tour. Thank you very much. All right, so this polling question: has your jurisdiction been on the gray list? And I'm going to assume more than 50% is going to be saying yes, given our audience. So Cayman was on the gray list. How long was it on the gray list? 3 years, Elizabeth?
Actually, Kimberly, I have a slide coming up on that.
Oh,
So
okay. I won't ruin
it
it.
was,
I won't ruin it.
yes.
And I know BVI is on it as well. And who else is on it in the Caribbean? I think I should know this off the top of my head, to be honest with you. Is it? Oh, I can't remember. Sorry, I don't want to say anything. All right, so yeah, so our poll results, we have 77% are saying yes. And given our audience is a lot of Cayman and BVI, we are, I'm not surprised with that number. And I'm sure you all felt some impacts as well. So we can close that poll now, Tom and Elizabeth.
Thanks, Kimberly. And I can now answer two of your questions. So the first question is, who is currently on the grey list? So you can see here the current list. The list is subject to change 3 times a year at the FATF plenary meetings. So the last one was February 2026, which of course is important for industry who are monitoring.
I just lost sound from Elizabeth. Tom, can you
I
still?
have to.
Okay,
I
it's on
cannot.
your.
Oh, okay. Yep. Sorry, Elizabeth, we just lost your sound for a second. Go ahead.
Okay. I was just saying that we can see that Virgin Islands UK, as you said, BVI is on the list. And we also have Monaco over there on the right, which I'll talk about in a moment. So I don't know if you heard me say this list is subject to change 3 times a year, which is the 3 FATF plenary meetings that take place, the most recent one being February 2026. So your second question, Kimberly, about the Cayman Islands and how long it was on the list for. The Cayman Islands was added to the list in February 2021 and was removed in October 2023. So I think you said quite rightly, Kimberly, just over 2 years. And so you can see that the timeline for the Cayman Islands, and that now takes us into, in not too long after that delisting, the submission of the documents for the next on-site inspection. So a lot of our audience, their countries were subject to the grey listing, and for those countries, there may be a short time period between delisting and preparation for the next round. It may well overlap because, as I said, it will be looking at 4 to 5 years of statistics. But that should be helpful because countries who have done enough to be delisted should, if they maintain that level, be in a good position to provide the required information for the next round. So looking then at what brings a country to be on the grey list, there's 2 parts to this process. The first one relates to what ratings it received. So we looked at the different ratings that are available, and you can see at C, if a country receives low or moderate for 9 or more, and 2 of those are low, or if it has low for 6 or more, then it will be put in the ICRG process. There's also the possibility of nomination, but normally it's to do with those grades. So 1 bad rating for 1 IO would not be sufficient. That's part 1, to be subject to the ICRG process. But then who is subject to active review? So a review by FATF. So this is where the process has changed, because what has been added is that, first of all, if a country is on the World Bank high income countries list, which is a public list, then it is going to be prioritized for this active review. So previously we had the broad money figure, which obviously in the case of the Cayman Islands, it was met and it was subject to active review. But now we also have, if you are on the World Bank high income countries list, so that includes more countries than would otherwise, who may not have met or may not meet the broad money figure. And then importantly, we have the least developed countries, which is a public UN list. Now, these countries will not be prioritized for active review unless the FATF agrees that they pose a significant money laundering, terrorist financing, or proliferation financing risk. And in that case, they would receive a 2-year observation period instead of a 1-year observation period. And this will hopefully help to counter the fact that a number of African jurisdictions, for example, have featured on the list. And in fact, the FATF stated that they anticipate that this should halve the number of those least developed countries featuring on the list. So that's one of the key changes, which I think is a welcome development in the next round. The other point I wanted to bring to everyone's attention is that being on the grey list is not a call to action by FATF. And FATF goes on to say they don't envisage de-risking, cutting off entire classes of customers, but they do call for the application of a risk-based approach. So what grey listing means is countries are actively working with FATF to address their deficiencies, and they must commit to this high-level political commitment to achieve the actions that they've been placed on the grey list to remediate. And the grey list is not actually technically called the grey list, it's called jurisdictions under increased monitoring, to make that clear that these are jurisdictions who have committed to improving and that they are under this increased monitoring as they remediate those actions. So what FATF says is it encourages all its members to take into account the information provided. And I've used Monaco as an example here. So Monaco is currently on the grey list. And if you scroll down to Monaco on the FATF website, you can see the actions that they have completed thus far at bullet point 1 and the actions that they still need to complete at bullet point 2. And you can do this for any country on the grey list. So it's important when you're considering your countries of higher risk, and particularly those countries which private sector industry interacts with most frequently, that you understand the type of risk that that country poses. Now, even though it's not a call to action, of course, grey listing, as you said, Kimberly, has severe consequences. So consequences are reputational in terms of both at the individual and entity level, as well as at the national level, and the viewing of the jurisdiction. Political in terms of a potential lever to other countries who may wish to use this, and financial in terms of investment into the country. So the consequences are significant and can be severe, particularly in terms of correspondent banking, which we saw for some of the CFATF countries. I just want to make the distinction here between, we talked about grey listing is not a call to action, but of course must be taken into account in terms of risk and has severe consequences. Then we have the blacklist, which is technically called high risk jurisdictions subject to a call for action. And we have 3 jurisdictions, DPRK, Iran, and Myanmar. In the case of DPRK and Iran, there is a call to apply countermeasures, for example, terminate correspondent relationships, and in the case of Myanmar, to apply enhanced due diligence. So that's the distinction between the grey list and the blacklist. Now, the last thing that I wanted to talk about, Kimberly, that we've touched about as we've gone through is the role that industry plays in these mutual evaluations. So first of all, leading up to the mutual evaluation itself, we looked at the 11 immediate outcomes, and those which are most significant in terms of industry and industry's involvement is, of course, immediate outcome 1, risk, which we looked at, and then immediate outcome 3 and immediate outcome 4, depending on which sector your private industry firm falls in. And here, in immediate outcome 3 and immediate outcome 4, the assessors will be looking at the level of compliance as found by the supervisor, as well as during those on-site interviews, asking questions in relation to the understanding of risk and, for example, SAR filing, in what circumstances, and application of CDD. And then immediate outcome 5, beneficial ownership. The assessors will be looking at how well populated the register is, whether that information is accurate. And then for sanctions, and in this case, it's terrorist financing and proliferation financing, but we have seen countries use, for example, Russian sanctions as an example to say these are not specifically in immediate outcome 10 or immediate outcome 11, but they show that the country is properly implementing sanctions and the industry is playing their role in responding to those sanctions and taking appropriate actions. So they're the immediate outcomes that are most consequential from an industry engagement perspective. And so it's really important that industry understands what's required and plays its role in complying. For example, in the Cayman Islands, the anti-money laundering regulations largely mirror the FATF requirements. The other item that is helpful for industry is to provide input into requests for consultation on legislation and guidance. So it shows, as you said at the beginning, Kimberly, that industry and government bodies are working together, that legislation and guidance is being evolved in such a manner that it takes into account relevant considerations, and also that when the legislation is final or the guidance is final, as well as conducting outreach at that stage, it shows that industry has an understanding because they've been involved throughout the process. Of course, engagement with the supervisor and outreach is really important, and the assessors will be looking at the number of outreaches conducted in different areas, who attended from which sectors, and what was the outcome of that outreach? What did it help to achieve? Public-private partnerships are becoming increasingly used and increasingly effective, and they again demonstrate this engagement between the public and private sector, which is really useful in, for example, international financial centers, where you may have great resources at banks or other institutions that can then be used to engage with law enforcement and help develop typologies. Or, for example, we see in the case of UK, who uses Gimlet, that particular pieces of information can be fed into industry and provide results back to law enforcement, which can be really helpful. Participating in risk assessments is key, and providing assistance and feedback to those conducting those risk assessments, and of course providing assistance in promoting the jurisdiction's efforts, because often industry has those global connections both within its own group and at conferences and matters of that nature, where it can be useful to mention developments being made by the jurisdiction and to potentially overcome perceptions. In terms of the on-site interviews themselves, as I hope has been seen throughout this presentation, understanding the national risks, the risks of the sector and the sector of the client, so not only the sector that your firm is in, for example banking, but the sector of the client when conducting a client risk assessment, ensuring that you can explain how the entity level risk assessment was conducted and in what ways it took into account the findings of any national risk assessment. Any examples of the effectiveness of industry in compliance, and examples you can give of engagement, perhaps with a compliance association, or examples of other engagement. Examples of the input that's been given into the risk assessments or the legislative review. For example, with the BASP framework, there was use of the interactive hub. And then, as I said at the very beginning, undertake mock interviews so that you can better understand the types of questions that are likely to be asked and how you can prepare for them, and the types of examples that you can bring with you. So that was what I wanted to say about industry preparation, Kimberly. I know we're going to come on to questions. Shall we do that before I finish up?
Sorry, had to unmute myself there. Yes, thank you, Elizabeth. That last slide. I do have a lot of questions, but I'll go to the audience questions first. And sorry, hold on, just give me 1 second here. I think most of it, it was a lot of comments about the gray listing as well. Yeah, it doesn't seem to be a whole lot of questions. Somebody is asking about on the slide regarding asset recovery, what is the consequence to assessors if we currently still have no regulation and guidance from, it says the FRA when the Defense Against Money Laundering regime came into effect in January 2025. So this sounds like this is from Cayman, and it is, so the Defense Against Money Laundering Act did come into effect January 2025, so just over a year. Do we have numbers of how that's impacted the asset recovery in Cayman? I guess the
Yes.
asset recovery effectiveness in Cayman. I think I'm asking the question correctly.
So in terms of the guidance first, the regulations are due to come out any day now, I think. But the FRA took the proactive step of issuing notice, a FRA notice to industry to indicate what should be done, what the framework would look like, 7 days for deemed consent. So while assessors may consider the guidance or the regulations, of course, in terms of effectiveness, they'll be looking at how well the system is operating. So I think that in terms of the 7-day notice period, I think that has, it seems, been operating well. I know the director of the FRA has been doing a lot of outreach. I think one of the latest figures I heard was that there had been maybe about 10 or so refusals and a large sum, maybe 10 million. I don't want to misquote what he was saying. And so there have been refusals, there has been amounts frozen, which of course is what the assessors will be looking at. So I myself don't know when the guidance will come out, but I think it will come out when the regulations come into force.
Okay, but for the mutual evaluation review itself for next year, we do have some basic numbers like number of SARs, number of refusals, and the number of the amount frozen. And you said the effectiveness is not just about the dollars amounts and those numbers. It's also about, you said the system, is it operating effectively? Are you talking about like their tech systems, like, you know, the online, you know, submitting a defense against money laundering SAR? Is it that kind of systems processes that you're looking at as well, that they are looking at?
That's one thing that the assessment team will be looking at, but I'm more broadly in terms of, is the system as a whole functioning? So are people filing these defenses against money laundering? Are they being looked at? Are they being analyzed? Are requests being refused in appropriate cases, which is why it's significant that we do have those examples? And are they being passed to law enforcement, and is action being taken, for example, by way of restraint in order to restrain those funds? Because of course, these are only temporary provisional measures, and they are brought in to prevent the dissipation of assets in order that we can then use our tools that we already have, such as restraint, to go to court and restrain those funds. So it's looking at the system as a whole whether it is effective.
Okay. I have another interesting question here from the audience. And I think this, he's from Cayman, but I think I have seen this in other jurisdictions as well. And the question is regarding, so AML regs say we have to do due diligence or KYC on 10%, shareholders with, or, voting rights. But the Beneficial Ownership Transparency Act only applies to 25% test of identifying who's the beneficial owners. And this is kind of a operation procedures question. It's like, okay, so we've got the KYC on our 10% shareholders, but obviously a beneficial owner might not be a direct shareholder. So he's asking, how can we show strong compliance to regulators with this kind of difference in the 10%, 25% rules? Does that make sense?
Yes, that is quite a common question in the Cayman Islands, and in fact in other jurisdictions as well. So first of all, that system is compliant with FATF requirements. So the beneficial ownership registry at 25%, that is compliant with FATF requirements. The 10% is also compliant. In fact, it goes beyond what is technically required, but it does apply to those the regulated entities who are acting as gatekeepers. So in terms of beneficial ownership registry, we have a register of everyone 25% or more. In terms of going to our, for example, trust and corporate service providers, they will have a record of everyone of 10% or more. So in terms of the question, and how can both be right, they're both technically right. An issue that could hypothetically arise is, are we confident that industry is not confused by this? And I think in the Cayman Islands, we can all say with confidence that they are not, and that a lot of work has been done on outreach. And in fact, that 10% has been in place for a very long time. So that's the only way I could sort of imagine it becoming an issue. And I don't think that is an issue. And both systems are compliant with the FATF requirements.
Okay. I think it's, yeah, there might be more to the question as far as partnership interest, but but it's a good question. I'm going to have to kind of dig into it a little bit, but I think that can be addressed maybe separately or in an article, follow-up article or something. Somebody else is asking, considering the current AML regime within the Cayman Islands, and I apologize if for those who aren't in the Caymans, but we all have these issues. We're just using Cayman as the key example here. Considering the current AML regime within the Cayman Islands, which areas would you consider are our greatest weakness?
Well, I think we can look back perhaps at the 3 items that place the Cayman Islands on the grey list: the enforcement actions by CIMA, the adequate and accurate beneficial ownership, and whether sufficient action was being taken in cases where that wasn't being provided, and also in relation to money laundering investigations and prosecutions in line with the risk profile of the jurisdiction. And I think that third one is something that countries really find difficult, particularly international financial centers that are relying on mutual legal assistance requests and evidence from other jurisdictions. So I think that is going to be an area, now that we see an increased focus on effectiveness, an increased focus on risk, and making sure your actions are commensurate with risk. I think that is going to be an area that jurisdictions, particularly those which are IFCs, will find challenging, as well as, of course, the asset recovery, because again, that should be in line with the risk profile of the jurisdiction. So in the case where you are an IFC with predicate overseas of funding, the funds may have passed through directly or indirectly, but they may well no longer be in the jurisdiction. So it does take increased skill and expertise to trace and recover those funds. So I think those are going to be difficult areas for jurisdictions in this round, as well as, of course, the increased risk of crypto, how that's being taken into account, and virtual asset service providers being a relatively new area, and ensuring that they are being properly supervised and monitored.
Okay. All right. There are a few other questions. I'm afraid they're going to get us down into the weeds, and I want to stay focused on the whole assessment process, but I will look at some of these questions after this ends. I noticed that there was, I'm going to return to the slide if you don't mind, because we were on it for quite some time. I think it was this slide here, which is like for the compliance for the private industry who are preparing for the mutual evaluation in their jurisdiction. There seemed to be a lot like engage with the word engage was kind of caught my eye. You were asking the private industry, please engage with the supervisor, engage in outreach. How are we doing in, well, let's just say let's use Cayman. Do you feel that there is enough engagement with the supervisors? Um, do you think we need to do more? Are we waiting for the supervisors to engage with us? And what are your thoughts on that?
Well, I think in terms of individual firms, it's always good practice to have a good relationship with your supervisor. And I think generally Cayman firms do quite well with that. I think in terms of outreach, we are seeing numerous events. I know there's an event coming up in relation to on-site inspections, which is a private sector event, but there are members of CIMA speaking. Cayman Crypto Week, we just talked about the increased risk in that area and the focus on it. And we saw members of CIMA speaking at that event, including the head of the virtual asset supervisors, virtual asset service providers division of CIMA. So I think that's all very good. As I said, we'll need to know how many, the assessors will need to know how many attendees were there, from which sectors. And as I said before as well, in terms of outreach, we've seen, for example, the director of the FRA doing a large number of outreach in relation to this consent SAR regime. So again, that's very helpful to show that industry understands, it's been explained, and in fact then it does seem to be working in practice.
Okay. Any if somebody was feeling like they didn't have enough engagement with this supervisor, is there anything that you would recommend? Or are you saying that they should just reach out, or they should be attending as many of these events as possible?
Certainly attending the events, because of course it's also a requirement for industry to demonstrate the training that they have undertaken. So you've got the obligation on the supervisor to provide the outreach, and then the obligation on industry to undertake training and keep a record of that training. So hopefully that's something that everyone's doing anyway and keeping records of it. So both to learn from the event and find out what the latest developments are and what's coming up, as well as to ensure that you're keeping up your obligations in terms of your AML training requirements.
Okay. Didn't know if anybody had any questions. Oh, somebody is saying there's a LSSA webinar on 23rd April. Karen, if you want to send that to us, I'll be happy to let our Cayman audience know more about that.
Yes, and that's important, Kimberly, for our DNFBPs. So there was a general DNFBP outreach for all the DNFBPs, which included CIPA for the accountants and LSSA for the lawyers. And then that one that's now being referred to, which I think is next week, is an LSSA specific one. So again, a good example of engaging with the supervisor, finding out what guidance they're giving and what's coming next and what to look out for.
Yes. And the FA, somebody else is asking, says, does the FATF recommendations, sorry, this is regarding beneficial ownership, and they were just wanting to know about the provision of ownership. I think, again, really, that's really a separate topic, but just to put it out there, it's like somebody is asking if the FATF recommendations require the provision of ownership information relative to every layer of ownership in addition to the BO, ultimate beneficial ownership information. And again, I think that's one of those areas where we might have to kind of address that in a separate webinar. Some of these 25, 10%, rules, the differences, and how much KYC and due diligence needs to be done throughout the layers. I'll respond from a compliance officer perspective, somebody who's actually done the job and drawn out these structure charts. I try and do KYC on just about everybody that's 25% over, looking for, obviously some exemptions when I can, or, simplified measures when I can. But it's always been when you're doing the due diligence, you might find some other connection and then some other connection, and then you start realizing, oh, there's more to this picture than what it looked like originally. But I don't know if I was going over, or if that was an actual requirement. But I think that's a legal question, maybe in each jurisdiction. Would you agree?
Yes, I think, as you say, you could do a whole webinar just on
Mm-hmm.
beneficial ownership, and also on discussing the 25% and the 10% requirements.
Mm-hmm.
But I do think that industry in Cayman and in other jurisdictions has demonstrated its understanding and compliance with those regimes, which of course is what the assessment team will be looking at. So we'll see that in terms of immediate outcome 5 when they make their findings, in terms of how well the beneficial ownership is being collected and verified. And then in terms of immediate outcome 3 and immediate outcome 4, how well those regulated entities are complying with their obligations in relation to their clients.
Okay. Do you know when, again, another question, somebody's asking, when will the Cayman Islands National Risk Assessment be completed? She wants to integrate it into their business risk assessments. And I do have a question about a follow-up question to that for TCSPs, but do you know when that's going to be finished?
So I think Ministry of Financial Services issued an updated fact sheet in relation to the NRA, which is on their website. And I think the update was Q2 2026.
Okay, so any minute now. Yeah, it's obviously I try and help a lot of different trust and corporate service providers implement their AML compliance requirements. And I will look at the national risk assessments for the country whenever I'm also looking at usually their AML manuals or policies and procedures. And when it comes, I even had this question yesterday, because they were saying that the registered office services being provided by trust and corporate service providers is often high risk in that jurisdiction. Does that mean that they have to, every time that somebody was saying, does it mean we have to implement, make a client that we're providing registered office to as high risk? And I was like, well, to me, that's operationally inefficient. You can't do that if that's your business. How do we marry what a national risk assessment report will say is a high risk industry or service in that jurisdiction when you are the service provider of that particular service?
Yes.
Have you kind of had that challenge?
Yeah. Yeah, so we've got the national risk assessment, and we've got sectoral risk assessments, often conducted by the supervisor. And of course, for example, if you look at a sectoral risk assessment, it's looking at the sector as a whole. So we're looking at the entire sector and making these findings. Then you've got your your entity level risk assessment. Now, the entity level risk assessment obviously needs to look at the national risk assessment and the sectoral risk assessment, but it doesn't mean that every single entity that's providing that service will fall into that generic finding. However, it does mean that you must carefully understand the factors that were taken into account, how that rating was reached. And if you then distinguish your entity from that, you must document why that is the case.
Okay, I like that answer. So we need to identify how that we as a regulated entity are addressing that particular high risk sector, such as providing registered office services. And we would really want to just make sure we're documenting, yes, we understand that, and this is how we are reducing or mitigating that risk.
Yes.
Okay, so, okay, great, thank you. All right, it's top of the hour, and I'm looking at see if we have any more questions. I think we're good. Again, lots of beneficial ownership questions. I think we're really still struggling as a industry on the beneficial ownership. So we probably do need to have a webinar or more training sessions. So we will move on here. And thank you again, Elizabeth. I thought that was very, very helpful to understand that bigger picture of the mutual evaluation process. I really do appreciate that. And I know you're a real expert in it because you've been kind of doing it for some time. And you are also doing some in-person training in Cayman. Uh, so here's some key dates on that. And I'm sitting there looking at these and I would love to attend. 18th June and 27th May, Karina at claritaslegal.com. You'll need to email her to get some more, to either reserve your spot and get more information. But very good agendas, 2 different days. So one is geared to the AML compliance officer and the MLRO, and the other one's more for the for the directors, correct?
Yes, so the first session is director focused with case studies, red flags and obligations and liabilities for directors. And the second one is AML officer focused, so compliance officer, MLRO. But obviously, neither is limited to only those people, and others who may be involved in making decisions, senior management, members of the compliance team can also benefit from either or both of those sessions.
Okay, yeah, so this is, yeah, really good. I do recommend it if you are in Cayman and need to get there. Well, listen, and thank you very much. So if you are if somebody listening in is in the private industry and they are asked to participate in, I guess, in a consultation review or participate in interviews, you'd recommend they call you to kind of help prepare, correct?
So in terms of the work that Claritas does, we provide regulatory legal advice and representation and also compliance services from gap analysis, preparation for on-site, post-on-site, all those tricky beneficial ownership questions and matters of that nature. I think the assessment will be led by OSAFE, which is the new office inside the Ministry of Financial Services. So they will be in charge of deciding on who will be selected for those interviews.
Okay. Fantastic. Well, thank you very much. And thank you to the audience for joining us today. I hope you found this kind of high-level overview of the mutual evaluation process informative, and I hope it encourages you to engage with your regulators and attend various events for your industry and in your jurisdiction and learn more. Again, I've been a big proponent that regulators are trying to protect the jurisdiction, you're trying to protect your company, obviously, but ultimately we are on the same side, which is kind of interesting because last month I had a different speaker and we were kind of coming at it from a little bit of a different area. I believe that recording is up if you wanted to listen to him too, because he was very I won't say anti, but he was very saying, the AML regulations is just too much, it's complex. So we do try and look at everything from different perspectives, different angles, and just encourage uh, any kind of discussion. And a mutual evaluation and review process, it's very hard on the regulators. Give them a break if you can. Um, but it's something we do have to work together to prepare the jurisdiction. There was one comment somebody had made about that he had heard that there was no impact to Cayman when it was on the gray list. Elizabeth, would you agree or disagree, or there was very, very small impact? What would your thoughts be on that comment?
I I think that the impact, if any, was very limited, and I think that we certainly didn't see the impact in relation to correspondent banks that we've seen in other jurisdictions. When the Cayman Islands was listed, there were only those three actions on the list. So we saw how FATF encourages countries to take into account the actual risk posed by a country on the grey list, and the fact that there were only three actions, and each of those actions was sort of the end piece of a functioning system. So the supervisor was doing everything properly. They just needed more enforcement. The beneficial ownership system was in place. They just needed to enforce in cases of lack of accuracy. Investigations were being undertaken, but they needed to show the prosecutions. So I think in terms of the items that actually went on the list and what they related to, I think others looking at that could see that these were only the final pieces in an otherwise well-functioning system.
Okay, interesting. All right. Well, again, thank you very much, and thank you to the audience for joining.